Welcome to another episode of Unraveling Intellectual Property with Michael Stein. Today we have one of our esteemed interns, Hannah Walton, and thank you for agreeing to be part of this podcast.
Thank you for having me.
Why don't you tell us a little bit about yourself?
So I'm a senior at Temple University and I'm a criminal justice major, and I'm here in DC for the fall doing an internship program with my school.
And how do you like intellectual property so far?
I like it. I think it's really interesting and it's completely different from criminal law, which is usually the main thing that I've been learning about in my courses. So
Well, I do think I had you research something about uh, whether there's any criminal penalties for intellectual property, but that's for another podcast. You did some research on a trademark case, I believe. Why don't you tell us the name of the case and when it occurred, and a little bit about the facts.
So the name of the case is Mattel v. MCA Records, and it was argued in 2002, but it begins in 1997 with the Danish band called Aqua, and they released a song called Barbie Girl, and they're assigned to MCA Records. So in the song lyrics and the music video, the band is very clearly talking about the Barbie and Ken dolls. So just to give some lyrics, they say, "I'm a Barbie girl in a Barbie world. Life is plastic, you can brush my hair," things like that. And in the music video, the two singers, the main lead singers, they refer to themselves as Barbie and Ken. And in the music video, they interact with like big plastic pink set pieces. So it's very clear that they're talking about the Barbie and Ken dolls. So after the song is released, it becomes very popular, and it gets onto the music charts in Europe and the United States. And that's when Mattel, which is the creator of the Barbie doll, they sue MCA Records.
And I know this was 20 something years ago, but early 2000s, I'm guessing Barbie was popular even then.
It was, yes. So when I was doing some research,
You were probably very, very young at that time.
yes, but I do remember that in Pixar's Toy Story, the second and the third movies, there's an actual Barbie doll character. So that just shows that it's popular during the 2000s, and it's like a noticeable figure and toy for kids at least. And I also found that there were groups of people who were protesting the Barbie doll because they thought that it wasn't good for young girls. You know, it gave them it just wasn't a good role model for them. So during the early 2000s, both kids and adults, they're aware of Barbie, and it's popular, it's a household name.
Oh, you said Aqua and Mattel. Mattel brought the lawsuit, correct? What was their argument or what was their complaint? And then how did Aqua respond?
So Mattel they had a lot of complaints, but I'm just going to focus on two. So the first thing that they said was that the song creates a likelihood of confusion. So those that don't know, a likelihood of confusion for trademarks, it looks at two different trademarks and asks the question of if consumers are going to be confused and think that these two trademarks are related when they're not. So Mattel was arguing that consumers are going to hear the song and they're going to incorrectly assume that it's related to Mattel. And then their second argument was that the song creates a trademark dilution. So trademark dilution is when a confusingly similar mark or just like a third party harms the reputation of the original mark. So for this case, Mattel is saying that the explicit song lyrics harm Mattel's brand because they're geared towards kids. So the song is going to harm their family-friendly reputation.
And as a result of that, what did Aqua counter with?
So they countered with the fact that the song was a parody. So it's considered like artistic expression. So they had the freedom to put out the song because it's protected under the First Amendment. And then they also had a counterclaim of defamation.
And what did the courts decide?
So the case first goes to the district court, and they rule in favor of MCA Records, and they find that because the song is a parody, there isn't going to be any consumer confusion. So then Mattel appeals and it goes to the Court of Appeals and they uphold the ruling of the district court. So they have three main points. So the first, they find that the song or the name Barbie, they said that it assumed a role in society, and that just means that the song is, or I'm sorry, the Barbie name is very popular. So the court found that if they were going to restrict how the public uses the name Barbie, it would be infringing on basically freedom of speech. So one example that I found when I was doing my research is the brand Band-Aid. So when you're, which is a, so Band-Aid is a brand of bandages. And when you're talking to someone and they say, I need a Band-Aid, you automatically know that they need a bandage because they have a cut. So the court was comparing the Barbie name to, for example, Band-Aid. It's very popular.
Let me just ask you, sorry to interrupt. In the video, have you seen the video?
I have, yes.
Are they dressed like Barbie and Ken?
That's a good point. They aren't, no, they're not dressed like
Okay,
them.
so it's literally just,
Yeah.
I'll say just, but it's just the names.
Yeah, it
Okay,
is. So the main singer, she has brown hair, and it's like very distinct that the Barbie doll has blonde hair. The singer also has like a tattoo on her arm that's visible. So you know if they're like a family-friendly brand, you wouldn't see like tattoos. And the male singer, he was bald, and the Ken doll, it's like very distinct that he has blonde hair.
Okay,
So
all right. And MCA, which is, I guess, is the producer for Aqua. And what did they argue?
they
Oh,
argued, oh yeah, that
you started saying, let me continue.
Yeah, they were just saying that it had assumed a role in society and that it was like a very popular name. So then the court finds that it had assumed a role in society, so they couldn't restrict or limit the speech. They found that it was a parody because the song was making fun of the Barbie doll herself, not the Barbie trademark. So one example that they used was one of the lyrics are, I'm a blonde bimbo girl. So that's an example of them making fun of the doll. And then the third thing that the court said was that there was no trademark dilution because the song was considered non-commercial use. So non-commercial use is when a product, it doesn't have the main goal of getting compensation, and that is an exception under the Lanham Act. So the court held that there was no likelihood of confusion because it was a parody and there was no trademark dilution.
But Aqua weren't they selling the music? Okay, all right, I know that. Anyway, it's okay. And kind of an interesting point. So I know you're not an expert in the field, but what's your impression? What do you think? If you were the judge and you had the absolute authority, where would you come out on this?
I agree with the court. I think I would have said the same thing. We were talking before that the Barbie name is just so popular. I don't think that, you know, like a big corporation should be able to limit that kind of limit speech just because, you know, they don't agree with it or they find it annoying. And I also think that if I had like no prior knowledge to the song or anything, and I just sat down and watched the music video for the first time, I would have assumed that it was a parody. Like I wouldn't have thought that it was in any way associated with Barbie. I think that I thought that going into it because a couple of years after this case, Barbie or Mattel ends up buying the rights to the song, and then they change the lyrics and use it in their ads later on. But I think if I was alive at this time and I just listened to it, I would have assumed it was a parody. So,
Well, thank you. I know it's all new material for you, but it seems like you've learned something from this. And to the audience, thank you for tuning in to this episode of Unraveling Intellectual Property with Michael Stein, and look forward to seeing you on our next episode. Take care.